Okay, now we're moving on to the fact that the Biden administration is seeking to expand LGBTQ plus protections under the Affordable Care Act.
So, Department of Health and Human Services has proposed rules that would now prohibit discrimination against persons of race, color, national origin, gender, age, or disability in certain health programs and activities. In specific, federally funded health programs and HHS programs, the proposed rule would fortify the civil rights protections that were weakened in 2020 under the Trump administration. As part of Section 1557 of the Affordable Care Act, the proposed rule restates protection against discrimination based on gender, including sexual orientation and gender identity, as outlined in Bostock versus Clayton County. Further, the rule reinforces protections against discrimination when seeking reproductive health care. So, under Section 1557, individuals must be treated based on their gender identity when accessing healthcare facilities and receiving care. In addition, people who are labeled based on gender must be treated according to their self identified gender. What this is doing is it's allowing people across the nation to be able to access federal health care without discrimination based upon their sexual orientation or their gender identity.
It's interesting. I wish we had a legal consultant on the show that we could pull up for this, but I'm kind of curious what it is, and I'm sure there's plenty of precedent for this, but that a case is cited in the law.
Mhm.
Uh, because the whole thing is, we're seeing in the Supreme Court where a case is up for a case is decided, and that
Mhm.
establishes precedent for how the court is going to rule on a law in the future. And we've seen how that opinion can change
Mhm.
in the court system. And so it's kind of interesting to see in the law a case is written in there. So like
Right.
if that case is challenged in the court, does the law then disintegrate, or how does that work? Because the law is what the courts are supposed to base their decisions on, and
Right.
that's how they interpret the law one way or another to get to their decision. And so it's just kind of an interesting thought process for me to consider what it means to have a a court decision listed as reasoning in the law for the law itself. And like I said, I'm not being a legal, not having any legal knowledge. Let's just put that out there.
Right.
I'm kind of curious what the precedent is there.
Well, and legal precedence is there is no like formal sort of establishment of precedence. It is a tradition. If a case is decided, that case can be applied in comparative ways. Um, damn, I wish I could. I wish I could remember geometry. But there is this idea that if something is true over here, then by the similarity, this is true also over here.
Mhm.
Now, for instance, Roe v. Wade was a decision made based upon the rights to privacy. By removing that precedence, any cases or any laws that were written with the expectation of privacy as interpreted through a post Roe versus Wade legal system, all of that comes into question,
Mhm.
which is a point that's being made in social media. For example, HIPAA laws could now be challenged so that you do not have personal privacy of your health insurance information. So, if you go into a doctor and you receive treatment for something, your boss can now request that information and determine whether or not your job will continue based upon that information. It is no longer a violation of privacy because the precedent for privacy established under Roe v. Wade's interpretation of the the constitutional amendment
Mm,
now has underridden all of that.
yeah.
So a law that mentions a particular case as precedent can then be not just eroded, but anything that was built after that case can also be eroded, which
Mhm.
is why the Respect for Marriage Act is being pushed right now. Roe v. Wade is just a precursor to their attack on same-sex marriage and also same-sex sexual activity. The laws that establish that same-sex individuals have the right to marriage, and also that what happens in the privacy of your bedroom stays in the privacy of your bedroom, these are now also removed
Mhm.
because a precedent has been removed. So it's not a foundation, it's a tradition, but it's a very long-standing tradition.
Yeah. It's just disappointing to have this stuff brought to the fore recently. The things that we thought were bedrock, were foundational,
Mhm.
were set and solid.
Yeah,
There appears to be none of that in our government anymore, and that's a frightening thing. It's a frightening thought.
it is. We do not have the stability that we had.
Mm.